I think in both instances what you're dealing with is the extent to which persons to whom government are indebted can enforce collection of the monies owing from government. And you've heard the term sovereign immunities, and it's been tossed around. And I think that's the source of the confusion, because there are different types of sovereign immunities. There's immunities from jurisdiction, which means one state can't be sued in the courts of another state. And there's also immunities from enforcements of judgments had from different jurisdictions. And that's what the two recent pieces of legislation deal with. When you agree to submit a dispute to arbitration, to international arbitration, you waive sovereign immunity to jurisdiction. It means you can be sued. Legal proceedings can be taken in foreign courts, just as it has with regard to the arbitral award. When you look at the bondholder documentation, the sovereign immunity referred to there is the immunity from jurisdiction. Those are being waived. And it was waived in the case of the arbitral awards in relation to the Ashcroft group as well. Where you are with the latter case is asserting immunities from execution of the judgments. And those are a different set of immunities. And I think it's the difference between those that have caused some confusion.
So then, was there any need for the legislation that the government passed in the House and in the Senate to protect the central bank from foreign reserves, when in fact those could not be touched under any circumstances, and what the so-called Ashcroft Alliance is seeking is attachment to any results of commercial transactions in the US?
Well, where you are is immunities from enforcement, from execution of judgments. And it's always been the case. The starting point is to recognize that the laws that govern execution of a judgment are the laws of the place where the judgment is sought to be executed. So the relevant laws would be the laws of the US, not the laws of Belize. So that's the first thing. So you can't pass a law in Belize to dictate what is to happen in the US. It doesn't work that way. The laws in the US, the change in the law in Belize would only be relevant to the extent that the laws in the US allow some reference to it for the determination of one factor or the other. But the simple position is, and the simple fact of the matter is, that the laws of the US already confer an absolute immunity to the reserves, to the resources of the central bank, so that there was never any risk of execution against the reserves.